Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 149. We're almost at the 150 milestone. Apologies, I should say up front. I'm getting over a cold, as you can probably hear, so if I'm a bit blocked up, or please bear with me. And equally, if I have to put the recording on hold for a coughing fit again, please bear with me. Anyway, due to an administrative oversight, Mayor Brown have served up coffee, tea and biscuits in this meeting room today, so it seemed rude not to make the most of it. So yeah, if the sounds of coffee drinking too, there we go. Anyway, three cases we're going to be looking at cover quite a range of issues. There's a case which looks at whether it's unlawful discrimination to send a woman who's on maternity leave an email which she cannot access in connection with a potential redundancy exercise. Secondly, we've got a case in the Court of Appeal which looks at the law on territorial jurisdiction and collective redundancies. And finally, a case on health insurance policies and whether an employee could be dismissed whilst in receipt of money under the PHI scheme. As always, please don't forget the podcast's available via iTunes and the Mayor Brown website or YouTube, and the Twitter feed, Nicholas Robertson, Nicholas ROBER11. And we put out links to the cases on that Twitter feed too. We are now, I'm pleased to say, also on Spotify, Google Play and Yahoo. So Murdoch Empire, better watch out. Anyway, first case, South West Yorkshire Partnership NHS Foundation Trust and Jackson and others. This is an appeal by an employer which had lost a discrimination claim in the Employment Tribunal. What had happened was there was a redundancy exercise at the employer. The claimant was made redundant and there was a sort of mass group unfair redundancy claim brought. However, the claimant was on maternity leave at the relevant time, and she and two others, also on mat leave, also claimed alleged discrimination contrary to Section 18 of the Equality Act 2010. By way of reminder, Section 18 says that a person, A, discriminates against a woman if A, treats her unfavourably because she is exercising or seeking to exercise or has exercised or sought to exercise the right to maternity leave. Well, as I say, claimant was on maternity leave at the relevant time, and there was a meeting 26th of July, which she did attend, to discuss the potential for redundancies. And the next day, she and the other 18 claimants were put on an at-risk register. On 28th of July, an email went out from the Trust to those emails on the at-risk register. It attached a redeployment document and some guidance notes and requested people to return them, the document as soon as possible, in order for HR to commence matching vacancies with suitable applicants. The email was sent by the employer to the claimant's work email address, which she was not accessing whilst she was on mat leave. However, she found out that the email was circulating on the 4th of August, i.e. best part a week later. She calls into her employer and is sent a copy of the relevant form, which she gets. There was no evidence of her being disadvantaged by the delay in any way. Well, the tribunal, the Employment Tribunal, said discrimination had occurred. There was unfavourable treatment on the grounds that she had taken maternity leave, and gave her £5,000 for her pains. The Employment Tribunal said the claimant had a legitimate concern that because she was on mat leave, she was being kept out of the loop. The missed opportunity for her to provide her details promptly to the at-risk team and the ignorance of what jobs actually existed were a direct consequence, according to the Tribunal, of being on mat leave. Therefore, she was discriminated against under or pursuant to Section 18. Trust appealed, and they did so on three grounds. They said to the AT, first of all, there was no unfavourable treatment. It was simply an email going astray. They also argued the decision was perverse, and the EAT quickly knocked both these arguments on the head. The judge described both points as hopeless and said, having an important and urgent work message sent to an email address which one cannot access for some reason must, it seems to me, amount to an unfavourable treatment one way or another, unquote. And so say all of us. However, the Trust had also appealed on the grounds of causation, i.e. whether the necessary link had been shown between sending the email to the wrong address and her maternity leave. It was not enough, they said, that but for the claimant being on maternity leave, the email would not have been accessible for her. This submission was agreed with by the EAT. The EAT said that the question which the tribunal should have asked in deciding whether there had been discrimination contrary to Section 18 is why the email had been sent to a work email address. Here, there was no finding by the Employment Tribunal that the fact that the claimant was on maternity leave had operated on anyone's mind. There was no basis to find that the manager who sent the email was motivated by a discriminatory attitude in relation to the claimant being on maternity leave. Indeed, the EAT said, there was some evidence that it may have been an administrative error by the employer, which led to the email being sent to the work address. On that basis, the EAT sent the case back to the same tribunal to consider whether there was any link between the fact of the individual being on mat leave and the decision to send the email to her work email address. I think the case is a useful one. First, it is not exactly unknown for employers to forget that individuals are on maternity leave or absent by reason of sickness when redundancy exercises are going on. It's clearly right, and I think the EAT was very quick to agree with the tribunal on this point, that it was unfavourable treatment to send the email to the wrong address. Looking at the level of damages, I think most people take the view that £5,000 for an email which went to a work email address rather than a personal email address, and which was corrected within a week with no evidence of any substantive harm, is probably a bit on the steep side. But the report at the EAT stage is unclear as to what factors were taken into account by the tribunal in getting to that level of damages. And as I say, the whole thing has been kicked back to the tribunal to establish whether there was any discrimination in the first place. Equally, I think it's very useful to have a case that reminds the parties, and, dare I say it, employment tribunals, that it's not enough to show that, but for the claimant being on mat leave, the particular incident would not have happened, or the error would not have occurred. There does either need to be some evidence of it playing a part in the decision-making process for the employer, or that there is a discriminatory rule in operation. So that's the case of South West Yorkshire Partnership NHS Foundation Trust and Jackson and others, and the need to show more than a but-for test when deciding discrimination had occurred. Okay, next up. Seahorse Maritime Limited and Nautilus International. This is the first case to get to the Court of Appeal, as far as I'm aware, on the territorial jurisdiction of the English Employment Tribunals to hear a case concerning collective redundancy consultation rights. As we all know, Section 188 provides there should be collective redundancy consultation if 20 or more employees are being dismissed from one establishment within a period of 90 days or less. The issue here was, what do you do if the establishment is outside England and Wales? Well, facts are quite complex, and I'll do it in two stages. In summary, Seahorse Maritime Limited employ people to work on a fleet of support ships. They do not own the support ships. The support ships were owned by a company called Sea Lion. Seahorse, the employer, had a recognised union, Nautilus. So if there was to be collective consultation under Section 188 of TULCRA, then Nautilus would be the union for consultation purposes. Well, in 2015, a number of redundancies have to be made. Nautilus claimed there should have been collective consultation pursuant to Section 188, and it goes to the court on two preliminary issues. Did the tribunal have jurisdiction to hear the claim in the first place, the territorial jurisdiction issue? And secondly, was each ship an establishment, or was the establishment in the context of this business some other level or unit? The reason the establishment point was important was that it would almost certainly bring the total number of redundancies down below the level to trigger collective consultation, even if there was territorial jurisdiction. A few more facts may assist. Sea Lion, the ship owner, owned about 25 ships. They're support vessels. These tend to get chartered for a period of months, and they get stationed in a particular location or a limited area, and it's outside Great Britain. In the previous 18 months, before the relevant redundancies arose, the ships had been operational in 11 different countries, and all but 2 of these were outside Europe, let alone outside the UK. Seahorse, the employer, is incorporated in Guernsey, has a small office in Guernsey. The ship owner, Sea Lion, does have an office in Surrey. The contracts of employment were in a standard form for each of the individuals and would identify the individual employee, the ship name, if known, and the entity of the employer, i.e. Seahorse. The place of work was specified as being any vessel owned, managed or chartered by Sea Lion. A number of the individuals who were required to work for Seahorse were from Great Britain. Somewhere between 1 in 4 and 1 in 5 were British, and the rest were from other parts of the world. The Employment Tribunal and the EAT accepted that the tribunal had jurisdiction, and and that individual ships were not the establishment. In other words, they decided both points in the claimant's favour. And as I say, the establishment point was important because if each ship was found to be an establishment on its own, then the threshold triggering collective consultation wouldn't have been reached. Court of Appeal started by considering whether or not each ship was an establishment on its own before going on to the territorial jurisdiction point. And the issue for the Court of Appeal is that there are plenty of cases about establishment, but this case had a unique feature. The employer, Seahorse, did not own the ships. So the employees were not working at a site owned by the employer. Furthermore, when redundancy had been announced, they'd been announced on a general across-the-board basis for the employer. They'd not been run as separate redundancy consultations within each ship. Did these factors matter? Well, the court went through a very useful summary of the cases dealing with what amounts to an establishment, cases such as Rockfon, emphasised that an establishment needs to have a certain amount of permanence and stability, needs to be expected to perform one or more tasks and to have a workforce assigned to it, technical means, and a certain organisational structure, allowing for the achievement of those objectives. The Employment Tribunal had decided each ship was not an establishment. This followed partly from the fact that the ships were not owned by the employer. Therefore, the tribunal said they were not a distinct part of the employer's undertaking. Furthermore, the tribunal said, since the employees could be rotated around the ships in accordance with contracts of employment, this also suggested that each ship was not an establishment by itself. The Court of Appeal allowed an appeal by the employer. They accepted that each ship was an establishment. Individuals were typically assigned to particular ships for long periods. It was not relevant that there was a contractual right to assign them to different ships. It was clearly a self-contained operating unit. The only question, the Court of Appeal said, is whether it could be said to have a workforce assigned to it, and there was sufficient evidence on the facts to find that the workforce was assigned to each ship, the court said. It was also not relevant that the redundancy exercise had been run across the employer generally rather than by establishment. After all, as the Court of Appeal accepted, the consequence of the Rockfon case is that many management functions may be undertaken centrally without affecting the fact that an establishment can be much more local in nature. The workforce, they said, was assigned, in fact, as a matter of practice, to particular ships. The ability to relocate the workforce around ships did not undercut this. So on that basis, the Court of Appeal decided each of the relevant ships was an establishment. So employers win the first part of the appeal. Having done this, however, the Court of Appeal then went on to consider the second argument, which is whether the tribunal, the Employment Tribunal, had territorial jurisdiction to hear the claim. Both parties accepted that the test was, is there a sufficient connection, quote unquote, given that the employees working outside Great Britain. The Employment Tribunal had looked at this from the perspective of individual employees, and it found that UK-based employees did have a sufficient connection with the UK to grant the Employment Tribunal jurisdiction. The EAT, which had considered the case before it went to the Court of Appeal, upheld this finding on the basis that the individuals, the UK individuals working, were international commuters, which is another category of individuals who are able to establish a sufficient connection with the UK. However, the Court of Appeal allowed the employer's appeal against this determination too. The court pointed out that the right confirmed by Section 188 is a collective right. Therefore, according to the court, it made sense to focus on the establishment and the location of the establishment and whether there was a sufficient connection with the UK and the establishment, notwithstanding the fact that the establishment was outside the UK. It was not appropriate, the court said, in the context of collective redundancy rights to focus on individual employees. And the court pointed out, and I think they're right on this, there would be significant difficulties with an approach that focused on individual employees. Different employees might have different degrees of connection with Great Britain. It would be very difficult for an employer to know whether there was an obligation to consult collectively if it had to run tests to establish sufficient connection with each individual in its workforce. Similarly, in running an exercise, both the employer and the union could be in significant difficulties if the collective redundancy rights applied to some UK-connected employees, but the non-UK connected employees did not have those rights. On that basis, the Court of Appeal accepted the establishment did not have a sufficient connection with Great Britain, and therefore the tribunal did not have jurisdiction in the first place. I think the case is a really, really useful one, and that's why I wanted to go through it in a bit of detail. First, the definition of establishment. It's helpful that the case looks so carefully at whether there was a workforce assigned to the establishment. We now know that it's not a significant factor on its own that the employer doesn't own the location at which the employees are based, and equally, the existence of a relocation clause does not stop a workforce being assigned to a particular site. Similarly, the possibility of sites outside Great Britain being covered by the collective redundancy consultation obligations is probably one that hasn't troubled many employers so far. The employer won in this case, but I suspect it's only a matter of time before a case will succeed where collective redundancy consultation rights are established outside Great Britain because there is a sufficient connection between the establishment and the UK to justify the individuals being able to claim in the Employment Tribunal in England and Wales, for example. So that's Seahorse Maritime Limited and Nautilus International, and the test to assess whether an individual could bring a claim for lack of collective redundancy consultation, which included looking at whether each ship was a separate establishment. So then, third and final case, AWAN, maybe AWAN, but AWAN and ICTS UK Limited. This is a case dealing with permanent health insurance and whether an employer could dismiss a staff member lawfully despite the existence of the PHI and the fact the individual was receiving benefits under it. I don't think this case is setting any new broad principles, but it's a really good example of the way in which the employer could get itself into a mess through a combination of circumstances outside its control. The basic facts were that the individual started off working for American Airlines. American Airlines had an insurance policy with Legal & General. The contract of employment entitled the claimant to both contractual sick pay and the benefit of the long-term disability plan. There was no evidence that the underlying insurance policy was ever shown to employees or that the terms of the underlying insurance policy were drawn to their attention. In July 2012, American Airlines looked at cost savings and decided to outsource the area of work in which the claimant was employed. In October 2012, the claimant was certified as unfit to work because of depression. On 1st December 2012, the business was TUPE transferred to ICTS. It was accepted that the claimant's employment transferred to ICS UK Limited under TUPE. However, ICTS's UK Limited's insurers, Canada Life, refused to meet any obligations under the insurance policy for the claimant's PHI because he was already on sick leave at the point at which the Canada Life policy started in 2012. Legal & General stepped up and said voluntarily they would cover him for 2 years, but at the end of the 2-year period, the Legal & General cover fell away, and at that point things went off the rails. ICTS took the view that they were not obliged to provide cover. Legal & General took the view they were not obliged to provide payments because their voluntary concession had expired, and Canada Life took the view that it was not obliged to provide cover because the individual had been sick in 2012 when they went on risk. On that basis, and given that there was no prospect of return to work for the claimant, ICTS terminated his employment. Well, the claimant unsurprisingly brings a claim for unfair dismissal and disability discrimination. He said it was unfair to dismiss him whilst he was still entitled to long-term disability benefits. It was also unlawful discrimination on the grounds of his disability. His dismissal was clearly on the basis of something arising from his disability. It was accepted that the dismissal was connected with his disability in effect. So the respondent obviously had no option at that point. So the Employment Tribunal, had to decide whether the respondent acted reasonably or unreasonably in dismissing the claimant for a reason relating to his capability, and separately, in relation to the discrimination claim, was the dismissal a proportionate means of achieving a legitimate aim in the circumstances. The Employment Tribunal then decided there was no implied term in the contract preventing the respondent from dismissing the claimant for incapability whilst he was entitled to receive benefit. They said there was no implied term. They did accept that the respondent was contractually obliged to pay the claimant long-term disability benefits whilst he remained employed. However, the tribunal said, that did not cut across the ability for the employer to give notice. The Employment Tribunal also accepted that continued employment for the claimant would have caused operational difficulties, and so the dismissal was reasonable and a proportionate means of achieving a legitimate aim. Well, on that basis, the claimant, of course, applied to the EAT. The EAT, well, it took a rather different approach. The EAT said that since the Employment Tribunal had accepted under the contract of employment, the claimant had an express contractual right in the event of a relevant incapacity from work. He had a right to be paid 2/3 of his basic salary until he returned to work, or retired or died. The dismissal was both unfair and it was discriminatory. Although the respondent tried to point out that there were references to an insurance policy and a staff booklet given out to staff, and there were references to a long-term insurance benefit, the EAT pointed out the contract of employment was clear. The benefit was not made conditional on actually receiving a payment from the insurance policy. It was simply be treated as an indication that the employer was laying off the risk of the potential liability to make payments to the employee to an insurer. Although there was a notice pay period specified in the contract, this was in general terms. It did not deal expressly with the incapacity, with what happened in the event of incapacity. It did not expressly reserve a right to dismiss without cause, but given due notice, whilst sick benefits are being provided. The court said that if the employer was simply entitled to dismiss on notice without giving any grounds, or just by giving contractual notice in effect, the entitlement to PHI referenced in the contract ceased to be any entitlement at all. Here, the contract was known by both the employer and the employee to include the disability insurance plan, which would only work if the employee was eligible to receive the benefits, and to do that needed to remain in employment for the duration of the incapacity. Since the contract of employment would be inherently contradictory, the EAT said that on a proper construction of the contract, there was an implied term preventing the respondent dismissing in circumstances where the employee remained entitled to payments, incapacity payments. This term can be implied either on the basis of the officious bystander test or the business efficacy test. The AT said in the circumstances, once it had been found that there was a contractual term, it was necessary to remit the case back to the Employment Tribunal to determine whether the dismissal was fair and to determine whether the dismissal was justified. Obviously, knowing only what I know from the AT report, it's maybe hazardous to speculate on the outcome, but I don't think I'll be holding my breath on the employer's prospects of success in view of the AT finding. But let's see. So, I think the case is an important one. Employers may well assume that a reference to an insurance policy in a contract of employment dealing with sick pay benefits is enough to make the employee aware that the benefit is conditional on insurance cover. So if the insurers don't pay out, then the employer will not pay out. Alternatively, that the employer is entitled to dismiss on ordinary notice at any time if it so wishes. However, I don't think this is right. There really is no substitute being very clear with employees if you're providing an insured benefit, that the employer is only liable to pay out if the insurers pay out, and moreover, that the employer is entitled to dismiss on ordinary notice, even in the event of incapacity, if that is where you wish to go, or you need to say expressly, the employer is entitled to dismiss, but only in more limited circumstances, which have been carefully defined, if you wish to give a greater degree of security to the employee. So that's the case of R1 and ICTS UK Limited and the entitlement to avoid being dismissed where an individual is receiving incapacity payments. So that's it for this episode. Thank you very much indeed for listening to podcast episode number 149. I hope you also enjoyed the podcast with Chris Milsom, who was an excellent guest in our last podcast. If you've not heard that podcast, please do go back and have a listen to it. It deals with the incredibly important topic of suspension and when an employer is able to suspend an employee without being in breach of contract. What's the test? We're also, I'm pleased to say, going to have a slight revamp of the podcast, which I'm hoping will take place in podcast episode, the next one, 150. Seems an appropriate place to do a revamp. Wouldn't want to rush into any changes after, 5 years? 6 years? 7 years? 7 years I've been doing the podcast. Goodness me. Anyway, I hope you like the revamp, which will be in place for podcast number 150. Thanks very much indeed for listening. I'm hoping this will go out before the Easter break, in which case I hope everyone has a good Easter break. If it goes out after, I hope everyone had a good Easter break. Thanks very much indeed. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.